A witness is one way to get evidence before the court to support your case. Here we have Miss Gibla calling Miss Friendly, her friend and neighbor, as a witness. Anything that Miss Friendly says under oath at this hearing is called testimony. Testimony is one form of evidence that the judge may consider.
Notice that Miss Gibla has a list of questions that she's going to ask her witness. You too should have a list of questions written down so that you don't forget anything. Your questions should be clear and direct. Before the hearing, you should have already talked to your witness and gone over what questions you're going to ask him or her. By the time of the hearing, you should trust your witness to tell the story in his or her own words. Nothing that that witness says in court should be a surprise to you.
Note that Mr. Lawless, Mr. Filfo's attorney, is listening and taking notes. This is a good practice. If you're not asking or answering questions, you should be listening and taking notes as well. It will help you organize your thoughts if you want to ask questions later.
Ms. Gibla is asking questions of her witness or doing a direct examination of that witness. First, she starts by asking background questions like whether or not Miss Friendly knows her, whether or not Miss Friendly knows her ex-boyfriend, Mr. Filfo, and whether or not she knows their son, Tommy. This is important because you need to show that your witness has personal knowledge about what he or she is about to talk about. If you can show that your witness has personal knowledge, the judge will probably accept that witness's testimony.
Mr. Lawless, Mr. Filfo's attorney, has just made an objection. An objection is a way to keep evidence out of the courtroom so the court can't consider it. An objection is used to keep a witness from testifying about certain information, or it can be used to keep out other forms of evidence like a document or a photo. Whenever you make an objection, you must give a reason for the objection. Here the attorney said, objection, cause for speculation. Cause for speculation means that a witness is not going to be able to testify about something he or she does not have personal knowledge of. Let's see how the judge handles this.
When an objection is made, a judge must decide and rule on that objection. The judge may either sustain or overrule that objection. If the judge agrees with your objection, the judge will sustain. That means that the witness will not be allowed to answer the question or that some kind of offered evidence will not be allowed in. One way to remember this is that the S in sustain means S for stop. So that means that the witness cannot answer the question and the evidence will not be allowed in. If the judge disagrees with your objection, he will overrule it. That means that the witness can answer the question, or if you're offering some kind of physical evidence, that evidence will be allowed in and will be considered. One way to remember this is the O in overrule means O in okay. So the witness is okay to answer the question, and if there is some physical evidence being offered, it will be considered.
Here, before describing the incident, Miss Friendly has shown that she has personal knowledge of the incident by saying she was there when it happened.
Here's another common objection. Don't get frazzled. Just remember that whenever you or a witness talks about an incident, it needs to be mentioned when and where the incident happened. This is because it helps to establish that a particular incident is relevant. Usually, something that happened 2 weeks ago is going to be more relevant to your case than something that happened 10 years ago.
As we said earlier, objections are used to keep out evidence, like the witness's testimony. Hearsay is another common objection. The reason hearsay is not allowed into testimony is because it's not reliable. Hearsay is a statement that's being made by a witness on the stand or testifying in court about another statement that they heard someone else say out of court. It would be far better to bring the person that had originally said the statement into court and let them testify to what they have personal knowledge about. That way the judge can rely on the testimony. Now remember, there are many exceptions to hearsay, so it could sound like hearsay, and yet the judge may still allow it into evidence.
Obviously, the way Mr. Filfo just acted, that's a big don't. Just remember, as soon as you step in front of the judge, anything you say and anything you do can be considered by that judge. That's why it's so important to be prepared and to always be respectful in the courtroom. If for some reason you do get a warning from the judge, immediately stop whatever you're doing, listen very closely, and allow the judge to finish speaking. Then, very respectfully, apologize. That's it. Don't make the same mistake twice.
Non-responsive is another common objection. It means that the witness really isn't answering the question. Here, Ms. Gibla has asked whether her ex-boyfriend ever did anything threatening to Ms. Friendly. But instead of answering the question, Ms. Friendly begins talking about things really not related to the question. There's a lot of information that both parties wants the judge to hear about, but it's very important to keep your witness focused. Your question should be short and simple, and each question and answer should go to make a point in favor of your case.
Up to now, we've been dealing with only one kind of evidence, testimonial evidence, or something that a witness says in court. But there are other kinds of evidence. There's documentary evidence, like a letter or a contract. There's also physical evidence, like a wedding ring. And finally, there's demonstrative evidence, things like photos, maps, and x-rays. These aren't the real object, they only represent that object. Right now, Ms. Gibla wants the judge to consider a letter, which is documentary evidence. The evidence she is offering will be labeled and referred to as an exhibit. In order to have the judge even consider her evidence, Ms. Gibla has to offer that evidence or exhibit to the court. That means that her evidence needs to be relevant and authenticated. We've already explained that something is relevant if it proves or disproves something about your case. To authenticate something, you usually need a person who has personal knowledge about that piece of evidence to confirm it and confirm its reliability, and basically prove that it's not a fake. After that, the judge may admit your evidence along with the other evidence already offered to help determine the outcome of your case. Let's see what Ms. Gibla does.
You have just watched Ms. Gibla offer into evidence a letter from Mr. Filfo. This letter is relevant because it tends to show that Mr. Filfo has not only been threatening to Ms. Gibla, but to other people as well. Therefore, it could be in Tommy's best interest for Ms. Gibla to have sole custody over him. And it also might be in Tommy's best interest if Mr. Filfo has supervised visits. Ms. Gibla authenticated this letter by asking Mrs. Friendly what personal knowledge she had of the letter. Well, of course, she received it. And she also confirmed that she was very familiar with Mr. Filfo's handwriting. Let's see whether or not the judge will enter this into evidence.
Whenever you ask questions of another party's witness, you're doing what's called a cross-examination. Mr. Lawless is going to ask questions of Ms. Friendly. Ms. Friendly is not his witness, so basically, she's not going to really help out his client's case. So, Mr. Lawless is going to minimize anything that she has to say. Pay close attention to how he asks her his questions. He's going to try to keep her answers short, limiting them to yes or no answers whenever possible. Remember those notes that Mr. Lawless was taking earlier? Let's see how he uses those notes to ask Ms. Friendly these questions.
This time, Ms. Gibla has objected. If you're going to object, you need to stand up and say objection, and then give a reason for your objection. And you must do this the moment you see or hear something objectionable. That's why it's so very important that you listen very closely to what is being said in court. Here, Ms. Gibla is objecting to Mr. Lawless's question because she feels it is irrelevant and has no bearing on the case. The judge will probably ask Mr. Lawless how his question will lead to relevant information. Let's see what the judge does.
Although Ms. Gibla gave a good try in making her objection, the judge overruled or disagreed with that objection. So the O in overrule should remind you of the O in okay. That means that it's okay for the witness to answer the question. Ms. Gibla is about to testify. In your case, you might not have any other witnesses, and it might be up to you to tell your side of the story. Be prepared and organized in what you want to say. Just remember that since you're testifying, you'll be treated like any other witness. You've already been sworn in, objections can be made against you, and the other party or the judge can ask you questions after you speak.
Obviously, this is another big don't. There are signs around the courtroom, and the bailiff often tells you to turn your cell phones off. So, turn your cell phones off. Let's see what the judge does. Stipulate means to agree. So in an effort to save time and concentrate on issues that the parties are actually fighting about, both parties can agree on facts that are not in dispute. In this case, both parties agree that Ms. Gibla is unemployed.
Ms. Gibla offered the newspaper ads as her Exhibit 2. However, she doesn't need a person to authenticate the newspaper ads because newspapers are considered reliable by the court. All you have to do is show that the newspaper is somehow relevant or helps to prove something about your case. Here, in this case, Ms. Gibla offered the newspapers because they're relevant to help show that she needs more child support. Sometimes, certain kinds of evidence, when considered all together, help to prove one issue. These kinds of evidence are called circumstantial evidence. Here, in this case, Ms. Gibla offered 1. Ms. Friendly's testimony that Ms. Friendly loaned her money, 2. Evidence that Ms. Gibla lost her job, and 3. The newspaper ads about daycare to help prove that she needs more child support. These 3 things are circumstantial evidence, and they help to prove that one issue.
Another way to get evidence in is through judicial notice. Judicial notice will allow the judge to accept into evidence anything that is a readily accepted fact. A good example is June 12, 2009 is a Friday. Additionally, case information and judgments can be readily verified by the court. So, criminal cases can be judicially noticed. What this means is that past convictions can be brought up and considered by the judge.
Obviously, this is no kind of behavior for the courtroom. Always talk in a respectful manner and never speak to the other party directly, even if that other party is yelling at you. Let that party look crazy and unreasonable. This is emotional stuff. However, you need to control your anger, your hurt, and frustration. If you get into a shouting match with your ex, that only distracts from your case. Remember, the judge can consider anything you say and anything you do. You do not want the judge to think that you are the hot-tempered, crazy person. Stay focused, remain calm, and always be respectful.